Welcome back to the Law and Crime Network. I'm Heather Hansen here with Ken Belkin, and we have been watching some of the Curtis Reeves case, and they're now in a break in that, so we're going to take a little break while we step out away from that. But we do have good news in that looks like we're going to have some Whaley testimony later on this afternoon. What do you think about that case, Ken?
It's a very interesting case. I mean, I think he's overcharged. I don't think that they have any sort of evidence of an intentional killing here.
Let's back way up, because no one has seen, and no one at home, we've talked about it a little bit, but no one has seen a lot about what this case is about. So let's back up and talk about what it is that he's being charged with. This is Larry Whaley out of Iowa, who's being charged with shooting and killing Samantha Teeter, who was a neighbor of his, walking down the hallway of their apartment complex. He shot her through the door of the apartment complex and was initially charged with attempted murder because she was still alive, then charged with first-degree murder that has now been taken down to second-degree murder, but you still think it's an overcharge. Why?
Yeah, well, look, Iowa has a very interesting way of dealing with their murder statutes. And they have first-degree murder, which, involves willful. There's several scenarios where a first-degree murder charge can be brought in Iowa, where there's a willful, deliberate, and premeditated killing, when someone's killed during the commission of a forcible felony, usually robbery or a sexual assault, killed during the escape from, lawful remand, where you escape from prison if you kill someone. That would be first-degree murder. Killing of a public official, a child, or killing someone during the course of an act of terrorism. That would all qualify for first-degree murder. Now, what Iowa does, which is very interesting, I guess when they got around to writing their second-degree murder statute, they really simplified things. Right. And it's one sentence. It says, any murder that's not first-degree. Right. It's not how we do it in New York, right. No disrespect to Iowa. Right. But, we carefully craft our statutes. But they do have involuntary manslaughter, which can be an aggravated misdemeanor in Iowa. And two of the ways that you could be charged is if a person, unintentionally causes the death of another by commission of a public offense. That's not a forcible felony. I would say you might arguably have that here. Also, if a person unintentionally causes the death of another person by committing an act in a manner likely to cause death or serious injury. Two scenarios that I think are a little bit more applicable here than second-degree murder. I don't think that this guy had any idea, that he was going to kill this person. Yeah. He did know they were coming up the stairs because they have a weird little tradition in this building where when you come up the stairs and pass by Mr. Whaley's place, you better shine the flashlight and give a good whistle, which is what I do when I come up the stairs.
Anytime that you're entering someone. But let's back up on that, because that's some testimony that happened this morning that we were not able to watch here on Law and Crime, so not everyone may understand that. But from what we can tell, from what we're hearing from the courtroom, the boyfriend of Samantha Teeter, the boyfriend of the woman who died, testified that as he came up the stairs, he shone his light into the defendant's window and gave a whistle as if to give some sort of notice that they were coming. So I don't know how that's going to play into the defense to say, because part of his defense, I think there's going to be some mental status defense, but also he's claiming self-defense, that he was afraid that it was this Curtis and Heather May, who he had some sort of beef with, that he thought were outside of his door, and that's who he's going to claim he was shooting at. Ken, how do you think the self-defense plays in with what seems to be an issue with Mr. Whaley's mental status?
Well, look, first of all, it's not going to be self-defense unless they're in his home. Mm-hmm. If they're in his home, then the castle doctrine applies. You come in someone's home and you cause them to fear for their life, you better be prepared for them to employ lethal force against you. Right. And they would be justified in doing so in many cases, in many states. Some states, you don't even have to fear for your life. In Texas, for instance, if just by virtue of being on someone's property, they can kill you.
Right.
Not the way it is in New York. But look, as for his mental health, that's a separate issue. Could he not appreciate the wrongfulness of his conduct? Did he harbor some sort of paranoid delusions that these people were a genuine threat to his life? I don't know. They're going to have to elicit testimony to that effect.
Well, and it's intriguing to me because we've seen a lot of self-defense cases here at Law and Crime, and one of the things that we always say, was it reasonable to feel that you were in fear for your life? And if Mr. Whaley has some sort of mental defect, when does the reasonableness sort of overlap with what reasonable for him or reasonable for you or I? What's that reasonableness standard is not always well enunciated in case law and state to state. It's one of the things that came up in the Curtis Reeve case watching, that is it reasonable for an older man who is seated while someone's standing over him and maybe a little bit infirm to be fearful, where it may not be for someone like you or Aaron, who's going to join us in just a minute. So, those types of things, I don't know enough, and I know that, as we continue to watch and monitor this case, it's something that I think we'll continue to talk about.
Yeah, I don't know that they're going to get there with self-defense. Look, by all means, they need to try whatever they can to defend this man. Mm-hmm. But I don't think the self-defense argument is really plausible. Because, look, they didn't enter his home. They sort of gave him a warning. Maybe he was frightened. Being frightened because someone shines a flashlight into your window or yourself by using lethal force.
Right.
I live in Brooklyn. If any time someone made a noise or a disturbance outside my window, I popped off a shot, I'd be having a big problem with the Brooklyn DA's office.
Absolutely. Yeah, and shooting through a door, I mean, it certainly is reckless at the very least. And sort of falls into Iowa's very wide umbrella of second-degree murder. But I agree with you, and I think that the defendant was shocked.
But you still got to prove that you intended to kill someone to get the second-degree murder. I don't know that this guy intended to kill anyone. He might have just intended to give a little warning shot.
Well, and in that way, doesn't it almost seem like self-defense could hurt him? Because if he's trying to claim self-defense, he's going to have to say that he planned to shoot somebody, right? Or at least planned to hurt them because he thought he was defending himself.
Or just scare them off.
Yeah, maybe. Maybe. It'll be interesting to see whether he, and also in this case, whether he testifies in his own defense. Because we know that he's written a bunch of letters to the judge. He lost one of his public defenders because there was some sort of conflict. He kept writing to the judge outside of his attorney's knowledge. So that's the type of person that you might expect would want to testify in their own behalf.
Oh, yeah. I fully expect that he's going to want to testify. He has practically written a memoir to the judge.
Right.
This is unbelievable. As an attorney, I'm appalled. You need to get some control over your client. Take the pen and paper out of his hand. Stop writing letters to the judge.
How much can you do? I mean, it's going to be interesting to see how much control. There's an example on our screen of one of the letters that he wrote to the judge, and this is one of many. In this, he's talking about the motions that he's filed and cell phone records that he wants, and he feels as though evidence is being withheld from him, which is going to, there's Mr. Whaley there on the screen. I would not be surprised if we hear from Mr. Whaley, or at least he wants to be heard from during this case.